Good evening, everyone. My name is Jim Ogle. I'm the Executive Director for Freedom's Frontier National Heritage Area, and I'm so thrilled you're joining us tonight for another Portals to the Past event. And I think we could not have had a more timely event than tonight's not so minor, the Supreme Court denies women the right to vote. I am thrilled to welcome Sandy Davidson to us here tonight. She taught communication law at the Missouri School of Journalism for 30 years and also taught in the School of Law. She was a curator's distinguished teaching professor. She's retired now and is a professor emerita. And I want to welcome Sandy to our stage, if you will, even if it is a Zoom stage. Sandy, welcome. It's good to have you with us.
Thank you so much. Well, here is a picture of suffragettes, of course, and that is going to be the primary topic tonight, talking about Virginia minor and the right to vote. But I think tonight, given what's happened with Ruth Bader Ginsburg, that we really do need to start with her. This morning, I watched television coverage of RBG, the notorious RBG, as she's sometimes called, and I'm sure many of you did. Her body now is lying in the portico of the Supreme Court building, its main entrance, and I think it's so appropriate that engraved above the entrance are the words, "Equal justice under law." How totally appropriate. She was surely one of the great champions of women's rights of our time. Now, she had trouble getting a job as a lawyer when she got out of law school, even though she graduated #1 in her class at Columbia Law School in 1959. She'd gone first 2 years to Harvard. Well, of course, RBG pushed all of her life for gender equality. And that's her term, gender equality. We women aren't there yet, but we've surely made a lot of progress, and a lot of it is thanks to RBG. Now, a majority of law students are women. And Chief Justice Roberts mentioned that fact when he spoke at her service this morning. And by the way, a woman rabbi also officiated this morning. One of my favorite quotes from the notorious RBG is this, quote, "Fight for the things that you care about, but do it in a way that will lead others to join you," end quote. Well, I'm sure many of you have engaged in protest. I know that I have. Historically, maybe, let's go way back, the most famous lady protester, England's Lady Godiva. As the legend goes, in the late 11th century, she had a very cruel husband. His name was Leofric. He was a powerful earl. He was a lord. He imposed heavy taxation on his tenants in Coventry. So she protested to him. He didn't listen. So she did her famous protest, riding on a horse, not clothed, long hair down, middle of town, middle of the day, wearing, again, nothing but her long hair. The legend says that the grateful townfolk at least closed their shutters and stayed inside while she passed, with the exception of Peeping Tom. We won't go there. Her greedy husband then recanted. He rescinded the oppressive taxation. Probably few women today would have the daring or the hair of the horse by any stretch to replicate Lady Godiva's form of symbolic speech, but some American women have waged gallant battles and they deserve thanks from all of us who benefit from their efforts today. Well, Lady Godiva, a protester, protesting can be a noble activity, and we got many of these noble activities from the British, but we got some truly ignoble ideas, and this is where we need to start. One of the worst things that we got from Great Britain was coverture. And so we're going to talk about coverture as the backdrop of what made it so hard for women to get the right to vote. Coverture, spelled C-O-V-E-R, cover, ture, T-U-R-E. I call it the tie that binds. The sad fact is that the US laws and traditions were often used against women. And arguably the very worst handicap for women used to be marriage. Coverture was simply the condition of being a married woman. Now, US judges unfortunately adopt this legal horror, adopt coverture from their British counterparts. Now, under coverture, married women basically ceased to exist, okay? They had no legal identity of their own. With coverture, it was basically as if one organism, we're talking about the husband, had enveloped another organism, the wife, and produced as a result one organism, the husband. I kind of think of it like the movie The Blob, where you have the blob, the husband, absorbs its victim, the wife, and the result was a more bloated blob. Well, under coverture, the woman's identity as a separate being dissolved. Now, if you think the US Supreme Court favored women, I'd say, think again. Let's go to an old case, 1919. In Thompson versus Thompson, the Supreme Court ruled that married women couldn't sue their husbands for assault and battery. In that despicable case, the court explained how under judge-made law, the husband and wife were regarded as one. In part, the notion of coverture is based on religious beliefs, on the notion of two becoming one, and that, of course, can be a very beautiful thing. But the Supreme Court said in the Thompson case that, quote, the legal existence of the wife during coverture was merged in that of the husband, and generally speaking, the wife was incapable of making contracts, of acquiring property, or dispensing of the same without her husband's consent. So women, under coverture, couldn't make contracts, they couldn't buy or sell property unless their husband consented. So no wonder that it was called the disability of coverture. It was as disabling as insanity. And for example, the Supreme Court in 1850 said of this poor woman by the name of Hannah Turner that, quote, she was laboring under the disability of coverture and also of insanity. So basically, if you're a woman under the disability of coverture, meaning you were married, you were treated legally as if you fell under the disability of being mentally unfit or being a little child. Well, unless their husbands agreed, married women couldn't engage in any occupations that required them to make contracts or to buy or to sell property. And this effectively silenced their voices in commerce and in the professions. They didn't have the freedom to clean the home. Well, they did have freedom to clean the home that they couldn't own, or to clean the oven that they couldn't own. But once a married woman became a widow or divorced, that was a rarity, divorce was, she was then freed from coverture. Well, what about a woman abandoned by a husband? Coverture led to this silly conclusion by the United States Supreme Court in 1828, excuse me. A woman abandoned by her husband could incur debts, but the court said she couldn't sell any land to pay for the debts. And unless the abandoning husband had been gone for 7 years or agreed to the sale, she was just out of luck. While unmarried women were free of coverture and could enter into contracts and buy and sell property, unmarried women were still hemmed in by the males-only barricades erected around essentials of community life, such as voting. Well, states could pass laws to give women some protection, and some did. I'll mention, for example, in 1861, Illinois passed, quote, an act to protect married women in their separate property, end quote. It provided this: a married woman could have separate property she owned prior to the marriage or acquired by, say, an inheritance or otherwise, the court said, from anyone other than her husband. So in Illinois, at least, 61, a woman didn't have to turn over, for instance, the silverware that she inherited by from her mother to pay for her husband's debts. Well, in a world dominated by males controlling most of the property and all of the voting power, 19th century women had little voice, and on matters of national scope or even on day-to-day matters, such as entering into a contract to repair the kitchen sink, they were silenced. But as the century and the hardships wore on, women responded to the urge for greater equality. In increasing numbers, and despite efforts to silence them, women started to find their voices, which brings us to Virginia Minor. It was in this era and in this legal backdrop that Virginia Minor, a Missouri woman, let's say a strong Missouri woman, became a protester of the demeaning way women were being treated. Unfortunately, the US Supreme Court could brutally refuse to hear or to help women. Let's talk about Virginia Minor's case. Well, she was a very early proponent of the right to vote. She had been the very first president of the Woman Suffrage Association of Missouri. That was in 1867. That was 2 years before Susan Anthony and Elizabeth Cady Stanton had established the American Woman Suffrage Association. The following year, 1868, the United States added the 14th Amendment to the arsenal of protection for its citizens. So this amendment begins by declaring, and I quote, all persons born or naturalized in the United States are citizens of the United States, end quote. In Missouri, Virginia Minor, who was over 21 years of age, took the language literally. Here's what she wanted. She wanted to vote in the national election in 1872, but she was a woman, and the registrar, his name is Reese Happersett, and here's Reese right here. He would not let her register to vote. So she sued, and he won the suit. She appealed all the way to the US Supreme Court. The case is titled Minor versus Happersett, and it was decided in 1875. And the issue in the case was this: are women persons? Yes, the court said. So at least the United States Supreme Court did flatly declare that women are persons. And the 14th Amendment says all persons born or naturalized in the United States are citizens. But here's the question. What rights flow from the designation of women as persons and as citizens? Now, the court does not say what advantages come with being a citizen, opining it simply doesn't have to do that. Here's what the court said. The Constitution does not define the privileges and immunities of citizens. For that definition, we must look elsewhere. In this case, we need not determine what they are, but only whether suffrage is necessarily one of them. And the court said, no, it is not. So the huge question, does the 14th Amendment language of all persons give women who are persons and citizens the right to vote? And the answer was no, just plain old no. No law, the Supreme Court said, confers on women the right to vote. Now, the court used as evidence that the 14th Amendment did not confer on women a right to vote the ratification in 1870 of the 15th Amendment. So let's look at the 15th Amendment. It says, quote, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. So we have the 14th Amendment, we have the 15th Amendment. Nothing's going to help Virginia Minor. By the way, at that time, Missouri's Constitution said this: every male citizen of the United States shall be entitled to vote. Here's what the Supreme Court said in Minor versus Happersett. Quote, we have given this case the careful consideration its importance demands. If the law is wrong, it ought to be changed, but the power for that is not with us. So, end quote. In other words, the Supreme Court is saying, Virginia, go elsewhere. So, the court says to Virginia, okay, you're a person, you're a citizen, but you still can't vote. No law says you can, and we're simply not going to make any law for you. On June 4th, 1919, Congress passed the 19th Amendment. On August 18th, 1920, that amendment was ratified, and women finally got the right to vote with ratification of the 19th Amendment. It says, quite simply, quote, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Sadly, Virginia Minor never got to vote. She died in 1894. But she was inducted into the Missouri Hall of Fame in December 2013, and a bronze bust of her is on permanent display in the Missouri State Capitol. Let's look at another case. In this era, a strong woman was asserting her rights, or at least attempting to do so, in Illinois. Myra Bradwell is her name. And here's a picture of Myra Bradwell. Myra wanted to become a lawyer. But the Illinois bar denied her the right to become a member. She passed the Illinois bar, I think, fairly easily. That was 1869. But she had a physical condition that prevented her from entering into law practice, namely, she was female. And she was married. Back then, she could be the most brilliant orator of her time, but that made no difference. In 1873, the US Supreme Court upheld the Illinois court's denial of admission to Myra Bradwell. Why? Because of her gender. That was the sole reason. What about law at this time? Well, it said males could join the bar in Illinois. And when Bradwell had earlier petitioned the Illinois Supreme Court, she wanted relief, of course. She quoted the Illinois statute that said this: When any party or person is described or referred to by words importing the masculine gender, females as well as males shall be deemed to be included. So the masculine includes the feminine. The Illinois Supreme Court, though, said that this statute didn't apply, quote, when there is anything in the subject or context repugnant to such construction, end quote. And Illinois just simply thought that women practicing law was repugnant and thought that that was obvious. By the way, the very first section of the very first chapter of the Missouri statutes also includes similar language about how to interpret statutes. It says that masculine includes feminine. Now, this was so ridiculous that Missouri's prostitution statute used to say, a person commits prostitution if he engages or offers or agrees to engage in sexual conduct with another person in return for something of value. Wouldn't you think that if women had any of the area of the law sewed up, maybe it would be prostitution? But well, anyway, that statute now says he or she, referring to prostitution. Back to practicing law. The Illinois Supreme Court said that when the Illinois legislature wrote the law concerning licensing of lawyers, it never entered the legislators' minds that women should become lawyers. And here's a quotation from the Illinois Supreme Court when it rejected Myra Bradwell's appeal. It said, quote, that God designed the sexes to occupy different spheres of action and that it belonged to us men to make, apply, and execute the laws was regarded as an almost axiomatic truth. In view of these facts, we are certainly warranted in saying that when the legislature gave to this court the power of granting licenses to practice law, it was not with the slightest expectation that this privilege would be extended to women. End quote. When Bradwell appealed to the U.S. Supreme Court, the unsympathetic court not only denied her the right to join the bar, but even gave her a lecture, I think you could say, on the proper role for women. For example, in his concurring opinion in Bradwell versus Illinois, here's what Justice Bradley had to say. The civil law, as well as nature herself, has always recognized a wide difference in the respective spheres and destinies of man and woman. Man is or should be woman's protector and defender. The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life, end quote. So, Bradwell was not only turned down, she was lectured. Bradley, the justice, even explicitly invoked God. He said this, the paramount destiny and mission of women are to fulfill the noble and benign offices of wife and mother. This is the law of the Creator, end quote. Note that in front of the U.S. Supreme Court, Myra Bradwell, like Virginia Minor, excuse me, unsuccessfully invoked the 14th Amendment. It was ratified 5 years prior to the Bradwell decision. Remember, the amendment says in part that, quote, all persons born or naturalized in the United States are citizens of the United States and of the state wherein they reside, end quote. Well, clearly, Myra Bradwell was a citizen. She was born in Vermont and became a longtime resident of Chicago. But the U.S. Supreme Court declared this, that the right to practice law, quote, in no sense depends on citizenship of the United States. So citizenship gave you no right to vote, it gave you no right to be a lawyer. The court concluded that, quote, the right to control and regulate the granting of licenses to practice law in the courts of a state is one of those powers which are not transferred for its protection to the federal government. No, it wasn't a federal government matter. It was a states' rights matter. So Illinois was free to deny Bradwell a law license if it wanted to. Now, here's how this story played out. While Myra Bradwell's U.S. Supreme Court case was still pending, Illinois denied admission to the bar to a second woman, and her name was Alta M. Hewlett. Now, she and Bradwell joined forces. They drafted a bill to prohibit Illinois from excluding anyone from an occupation based on their sex, except for military service. So in March of 1872, the law passed. In 1890, the Illinois bar issued Bradwell a bar license without her ever reapplying. In 1892, the U.S. Supreme Court admitted her to its bar. By the way, if you're hearing any crunching in the background, it's my dog Snuggles. That's part of Zoom at home. Well, in the meantime, Myra Bradwell, who was married to a lawyer and had children, was no delicate, shrinking violet. She reminds me in a way of RBG. She was a successful journalist, and in 1868, she founded the weekly Chicago Legal News, and thus she became the first female editor of a legal publication in the United States. In 1869, a new group, the Illinois Women's Suffrage Association, convened in Chicago, and Bradwell became its corresponding secretary and spoke at the convention. She also told about the Suffrage Association in her publication, the Chicago Legal Times. Now, in 1871, the Great Chicago Fire destroyed Bradwell's offices. She rebuilt them. She operated her publication for 20 years, turning the Chicago Legal Times into the most widely circulated legal publication in the United States at the time. Now, in the third issue, she started her column. Law Relating to Women is what she called it. In one of her early columns, she said this: "We believe ours is the first legal paper in the United States to come out in favor of woman suffrage," end quote. And she also made this claim, and I enjoy this quote: "Woman has a right to think and act as an individual, believing if the Great Father had intended it to be otherwise, he would have placed Eve in a cage and given Adam the key," end quote. As a historical footnote, Bradwell helped Abraham Lincoln's widow, Mary Todd Lincoln, gain release in 1875 from an insane asylum after Robert Todd Lincoln had arranged for his mother to be involuntarily committed there. So she really did help out, Myra did. But like Virginia Minor, she died in 1894 and never got to vote. Well, there are a couple of other women who are certainly worth mentioning, and I'm just going to do that as kind of a footnote so we can talk a little bit more about RBG. Phoebe Cousins. And here's a picture of Phoebe. She was born in St. Louis in 1839 or 1842, sources differ, but she became the first female lawyer in the United States to graduate from a law school. In 1869, I think it's interesting, Washington University Law School, then called St. Louis Law School, admitted Phoebe, thus becoming the first law school in the nation to admit women. That same year, Iowa admitted the first woman in the United States to a state bar association, and that was Arabella Mansfield. Same year, 1869, Wyoming and the Mormon Utah territories opened the first voting booths in the country to women. Who could doubt the strength of pioneer women? 1871, Phoebe became admitted to the bar. She didn't practice much. Let's go on to Arabella Mansfield as our next person. Phoebe Cousins, by the way, did certainly support women's rights until late in her life, and she kind of changed her mind. But Arabella Mansfield, 1869. The Iowa bar admitted the first woman in the United States to practice law, and here she is, Arabella Bell Mansfield. Well, at that time, the Iowa law did say that any white male could take the test, but a forward-thinking jurist, and that was Judge Francis Springer, ruled that, quote, the affirmative declaration that male persons may be admitted is not an implied denial to the right of females, and Bell Mansfield became an officially recognized member of the bar. The attorneys who administered the bar examination recommended that Mansfield be admitted, saying, quote, she has given the very best rebuke possible to the imputation that ladies cannot qualify for the practice of law. Namely, she excelled. Well, Judge Springer ruled for her despite the any white male language in the law on bar admissions, and he relied on another statutory provision, the one which said that words importing the masculine gender only may also be extended to females, and he did that. Mansfield really persuaded the judge. Remember, Myra Bradwell had tried that same argument in Illinois, but her attempt failed. Well, the following year, Iowa amended its law on bar exams. It removed the gender restrictive language. Arabella Mansfield devoted a great deal of energy to women's rights to vote. In 1869, that was the same year she was admitted to the bar, she became a member of the executive committee of the National Woman Suffrage Association, which Susan B. Anthony and Elizabeth and Cady Stanton had created, and which pressed for more sweeping societal changes than only the right to vote. The following year, 1870, Iowa held its first statewide convention to push for women's suffrage, and Mansfield chaired that convention. She pushed not only for women's right to vote, but also for women's right to an education. She earned 2 Masters of Arts degrees at Iowa Wesleyan, the second in law. She became a professor of English literature at Iowa Wesleyan, later a professor of mathematics there. She was a Renaissance woman. In 1886, she went to DePauw University in Indiana. She was a preceptress of the Ladies' Hall and then a registrar. She finished out her life as a dean, serving as the dean of the School of Arts and then also as the dean of the School of Music until she died in 1911. So Arabella Mansfield became one of the first female professors of law, that reminds me of RBG, and one of the first female deans in the United States. Again, she was a Renaissance woman. But all 4 of these women, Virginia Minor, Myra Bradwell, Phoebe Cousins, and Arabella Mansfield, all died without ever gaining the right to vote. Well, we did get the right to vote in August 1920, but battles for our equality continue, as Justice Roberts said, though today, and I've seen it myself, the majority of women in law, now in law school, the majority of students are women. Same thing in the School of Journalism. So times have changed. And Ruth Bader Ginsburg was certainly one of those forces. To think that she could not easily find a law job, but finally she did, and she wrote such magnificent opinions. But I want to talk about the last case that she ever argued as a lawyer in front of the Supreme Court. It's a Missouri case. The name of the case is Durham versus Missouri, and Durham is spelled D-U-R-E-N, Durham versus Missouri. It was decided in 1979, and here's what happened. Billy Durham was convicted in Jackson County, Missouri for first-degree murder and first-degree robbery. Okay, he was a bad dude, I think we could say. All 12 of the jurors in his case were male. The U.S. Supreme Court pointed out that only roughly 15% of the people who showed up for jury duty were women. Here was the problem. Missouri law, both the Missouri Constitution and a Missouri statute, said that any woman who wanted to be excused from jury duty simply had to say, in effect, "Excuse me, I'm a woman," and she would be excused. So the Missouri Constitution said at the time, quote, "No citizen shall be disqualified from jury service because of sex, but the court shall excuse any woman who requests exemption therefrom before being sworn as a juror." And also a statute implemented that. It said, among other things, that these were the persons who could be excused from jury duty. Quote, "Any woman who requests exemption before being sworn as a juror." So women were exempt. All they had to say was, "I don't want to do this." At the time, only Missouri and Tennessee still exempted women from jury service upon request. So Ruth Bader Ginsburg was one of the two arguing attorneys. The U.S. Supreme Court, in deciding Billy Durham's case, said this, quote, "Today we hold that such systemic exclusion of women that results in jury veneers, that means jury panels, averaging less than 15% females, violates the Constitution's fair cross-section requirement." In short, Missouri law was violating the Sixth Amendment. It says in part, quote, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury." And then it goes ahead with the Supreme Court interpreting the Sixth Amendment to demand a, quote, "fair cross-section of the population for the jury to be impartial." Clearly, women, half of the population, we needed to be more represented. The court said that Missouri's exemption for women was an automatic exemption, and that violated the Sixth Amendment's fair cross-section requirement. Now, this was an 8-1 decision that Ruth Bader Ginsburg won. Justice Byron White delivered the opinion of the court. Only Justice William Rehnquist dissented. Well, Ruth Bader Ginsburg then joined the Supreme Court as a justice in 1993. She was a Bill Clinton appointee. And it was her final appearance, as I said, in front of the Supreme Court that she argued this case from Missouri. She argued that by making jury duty an option for women, not really a duty, Missouri treated women's service on juries as less valuable than men's service on juries. But Ginsburg also argued that this exemption for women was unfair to men because they did not have a similar exemption. So in sum, Missouri simultaneously devalued women and also discriminated against men. This kind of protection of women simply couldn't stand. Well, we've made some other progress. I'd like to mention just briefly the Lilly Ledbetter case. What does a woman want? That's often a question. Well, how about equal pay for starters? Lilly Ledbetter suffered extreme pay disparity, but she didn't find out about it soon enough to avoid an arguably outrageous statute of limitations. Sometimes it is hard for women to find out that they have been systematically paid less than men. Well, The statute of limitations, only 180 days. Her discrimination had started many years before. Well, the US Supreme Court ruled against Lilly Ledbetter, but Congress stepped in to right that wrong, and President Obama, as the very first law he signed the Lilly Ledbetter Fair Pay Act of 2009. Again, Obama's first signed into law action. Well, the Ledbetter Act effectively is retroactive back to 2007, the day before the Supreme Court's Ledbetter decision, and it provides this: an aggrieved individual may recover back pay for up to 2 years preceding the filing of an equal employment opportunity charge. So Ledbetter versus Goodyear Tire and Rubber Company, again, the Supreme Court did not help, but Congress stepped in, and so did President Obama. Well, I am a big fan of Oprah Winfrey, and here is a copy of her magazine. It says on page 90, under "Because this is the moment for a powerful new women's movement," this is from February of this year, O Magazine, it says, and I'll just quote, "Here are a couple of fun facts and one that's not so fun. Women have accounted for the majority of voters in every national election since 1964. They're increasingly powerful donors. In 2018, they gave over $100 million more to congressional campaigns than they had in 2016. Yet, despite some gains, the US ranks 77th globally in women's representation in government, behind even China, Afghanistan, and Iraq." I'm going to repeat that last part. Despite some gains, the US ranks 77th globally in women's representation in government, behind even China, Afghanistan, and Iraq. We've got some work to do. Oh, by the way, 2 days ago, NASA did announce that it's going to send 2 people to the moon in 2024, and one will be a woman. So that's some progress, sending a woman to the moon. Well, let's get grounded on some more earthly topics here. Jim, do we have some good questions coming in?
Sandy, thank you for introducing us to an extraordinary group of Americans, and I really believe can be American heroes along the way. No need to identify them by their gender in that regard. They are heroes nevertheless. So I wanted to tell our attendees that if they would like right now, they can click on the question and answer button, usually at the bottom of their screen, and type a question that I'll be happy to ask for them. Or should they like to ask that question individually, they can use the function of raising their hand electronically, and I'll call on them, open their microphone so they can ask a question. And I guess my first question I'd like to pass on to you, Sandy, is about some 22 years went between when Ms. Minor tried to vote and then she finally passed away. How did people treat her after the fact? The regular, how did society treat her for the 20 years after her court case? Was she a pariah for trying to get in, or did people hold her up as an example of, even though she wasn't successful, of something we should do?
Yes, well, I think people did, generally speaking, regard her as courageous for trying to assert her rights. Now, of course, there was a segment of the population that simply did not think that women should have any such rights. Women were going outside of their place, which was the home. But remember, she became a part of the suffragettes. I mean, there were a lot of women who joined in this campaign. And also, we had women who were showing their mettle, what they were made of in the territories. And they were making headway, getting to vote there before they ever got the national right. So it was kind of a mixed bag. I think anytime that you are a pioneer, a champion, you will certainly have your following from people who are on your side, who understand what you are trying to assert, the equality of women who are citizens to engage in the most basic right to vote.
I also would note that such an effort was made by these people and others to try to have the opportunity of casting that vote. How do you reconcile that with the many Americans who, quite frankly, have 1,000,001 excuses for why they don't go and vote? Now, I know that there are a lot of people that I would exclude from that stereotype. There are people who face great difficulties in trying to vote, but I've known people who've said things as simply as it's too nice a day out to go vote, who by the next election, the weather's too bad to go vote. How do we reconcile ourselves to those kinds of American citizens who won't value the privilege and the right? I shouldn't say privilege, the right and their responsibility to vote.
I think some people really do not understand the historical struggle. They haven't had to struggle for the right. And sometimes if you don't have to struggle for something, if it's given to you freely, you don't value it as much. Sometimes in darker moments, I wonder if people who really don't care and who haven't probably been taken the time to educate themselves on what they're going to be voting on, maybe it's kind of a mixed blessing that they aren't going to just, willy-nilly check boxes if they haven't taken the time. But it is an obligation, if you're a citizen, to try to be a part of this democratic process. I don't know. I would think that we've got giants. RBG, I think, has really impressed a lot of young women on the importance not only of getting out and voting, but of becoming part of the political process, working in the government, and what honorable work that is. So a step beyond just merely voting, actually getting in there and doing government work.
It's as you talk about that, I keep thinking about the fact that we have a tendency to take and pigeonhole or put in a cubbyhole. Well, here's women's history, and this should only appeal to women, and this is African American history, and this should inspire African Americans, or Native American history, and this should inspire Native Americans. And I think, no, I'm as waspy as it can get, and all of these people that we talk about inspire me. They're my history too.
Yes,
and you can't draw that line or draw a wedge that these people should be somehow only taught to the people whom they are similar to in that particular characteristic.
Yes. Well, I would like to make kind of a general comment, since you mentioned, African American history and all. The Supreme Court did not treat women well. But oh my, the Supreme Court's history when it came to the indigenous people, American Indians, the Supreme Court called Native Americans savages. And it did so up until 1950. By the way, I'm part Cherokee. And we have the terrible Dred Scott decision. Oh my, people is property. We have had cases of people of Asian descent, people of sexual orientation, not heterosexual. We have had discrimination by the Supreme Court, just historically. It's gotten a lot better here recently, but if you just go through the case law, read about savages, read about people as property, read about women as being citizens, but no right to vote. It's rather disheartening. But now, of course, we've got more women on the Supreme Court. I hear that President Trump is saying he's going to nominate a woman. So we're making progress, I think, on understanding such things as implicit bias. I know the Missouri Bar and the University of Missouri is very keen on trying to eliminate implicit bias and trying to make everyone who's part of the community aware of the importance of everybody in our society.
I appreciate that. And I guess for the final question I want to pass on has to do with, short of having folks all be required to watch you tell these stories, how can we best educate upcoming generations to these different kinds of heroes that haven't been prominent in past telling of American history?
Well, I really think that the internet has provided such a great resource. And if you're a parent, you can go online and find so many resources. And then schools are doing a better job on this. I know, in my lifetime, I have seen such changes. I've seen changes in attitudes, not only in the educational setting, but also in the professional setting. And if I can just tell a quick little tale, I had just been selected to be the communications law teacher at the University of Missouri. The year was 1989. And I was at my first convention, all excited to be there, sitting at a table with other communications law professors, and most of them were male. So a very prominent teacher in my field was sitting beside me. We were all conversing, and he said, "I know why you were selected as the communications law teacher at the University of Missouri." So I sat there. I thought, maybe he'd say, well, because I had my law degree as well as a PhD or something nice. What he said was, "Because you're a woman." And I think I did the worst thing to him that I could have possibly done. I just sat there and let his words hang. And he started turning redder and redder. Now, there is no way, I don't think, that a professor would make that kind of remark to a woman or somebody who belonged to a minority group. We've come a long way. And when I started to law school, women were not the majority. Far from it. I went to law school, started in Tate Hall at the University of Missouri. There was one bathroom for women, but finally we had gotten to be at least more than one or two. And it was impossible to have a bathroom break. I remember one young professor was chewing us out for being late to class, and I just politely told him, well, you should have to wait in the line for the women's bathroom. Then we got a new law school, and it has equal facilities for men and women. And as I said, the majority of women in law school now, the majority of students are women, and there are minority groups coming on board. You know, I just think sheer numbers are going to make such a difference. It's hard to discriminate against women when the women are in the majority. And not only law, but, you know, medicine is seeing such inroads.
Those are great points. Sandy, thank you so much for sharing these lessons and this time with all of us tonight. It is greatly appreciated. Thank you for telling us about these American heroes that we should remember and admire. Thank you all for being our attendees tonight. And we do hope that you have learned something that you didn't know before and something that you'll want to tell and share to others along the way. We hope you have a very pleasant evening. Take care, and thank you for joining us tonight.
Thank you. Thank you.